facts don't lie. And if you are diligent and can dig in and you're reading through emails and texts and looking at phone records and trading records and everything else, you start to build this three-dimensional story.
Welcome back to Seasoned Friends, where we talk with legal leaders, technologists, and operators building the future of legal and doing it with humanity. I'm your host, Cecilia Ziniti. Today's guest is Rebecca Fike, a Chambers-ranked enforcement lawyer and partner at Reed Smith. Before going into private practice, she was 10 years as a senior counsel at the Securities and Exchange Commission. Reed, complete boss lady, who had subpoena power, issued thousands of subpoenas, and led major investigations that you've heard of into corporate disclosures, insider trading, whistleblower matters. If she was knocking at your door, it was generally not good news. But now she's in private practice. I have known Rebecca for literally 18 years. She runs a blog called Lag Live that inspired me both to go to law school and that I could balance kids and a career in law. She's written continuously on that blog since 2005 and is just an incredible person that is genuinely a friend I'm super excited to talk with today. Today, in terms of work, she helps companies and boards navigate enforcement risk, crisis response, and governance. And she's one of the most thoughtful voices out there on mentorship, big law, how AI is reshaping the profession. If you have any questions about the Securities and Exchange Commission, I can think of no one better to ask them. So let's dive in. We're going to talk today about learning, leading, keeping law human. We'll get into some things around kind of AI, around current enforcement priorities. And I'm just so delighted. Let's get into it. Rebecca, I'm glad you're here. Welcome to the show.
Thank you so much. I'm so excited to be here.
Awesome. So you spent a decade at the Securities and Exchange Commission before going back into private practice. What drew you to that kind of work in the first place?
So I started out in private practice and I was quickly becoming a mid-level associate at a large law firm in Austin, Texas. And this was in the early or mid 2000s, before Austin was quite the business powerhouse I would say it is now. And I was kind of looking around and thinking, where is my next work coming from? What am I learning? Who am I learning from? What do I really want to do? And at the time, I was starting to do more IP litigation just because that was busy in Austin. You, as an associate, you do whatever needs to be done. And I was seeing that I was quickly becoming more and more knowledgeable in it. And that wasn't what I wanted to do. And I really wanted to do securities-based work. There wasn't a lot of that in Austin. There is a lot of that at the SEC. And so I applied for a position. I think I studied as hard for that interview as I did for the bar exam and got that job and moved my family, which was then two kids, to Fort Worth, Texas, where the SEC's regional office is.
So you had some big cases at the SEC, accounting restatements, fraud investigation, criminal actions. So two questions. One is, have you ever put someone in jail? And then two is, what are the biggest learnings from that time?
Yes. So I personally, as an SEC enforcement attorney, only have civil power. It is limited, which my children were always very disappointed to learn that I wasn't as cool as it sounded. But I did work on several parallel criminal actions with the DOJ, and yes, had multiple defendants who did end up going to jail. And worked with the FBI and Postal Inspection Service as well when investigating those, parallel criminal cases. Main takeaways from that job, I would say, is that, facts don't lie. And if you are diligent and can dig in and, you're reading through emails and texts and looking at phone records and trading records and everything else, you start to build this three-dimensional story. And that to me was the most fun part of the job. And honestly, what drew me to being a litigation associate in the first place was it's a story. You're building a story and then you're trying to figure out how to tell it.
That fact don't lie statement. I think it's something that as lawyers, it's the literal truth, right? So people talk about, I had a post on LinkedIn this week where someone was citing the few good men line about you can't handle the truth, right? So how does that, when you say facts don't lie, like what does that mean for how a company operates or how you advise or pretend that I'm a brand new associate working for you and you're kind of explaining this concept. What are you telling them?
Great question. It's actually, as you were saying that, I'm like, it's a lot more nuanced than that because Facts don't lie in that that is how they are viewed by other people, like the jury, judge, other side. But facts, as you read them in an email, a text message, or certainly a person's recollection, those lie all the time. And so, one of the things I tell clients so much now is that like documentation and process are your friend. Like, I understand the instinct sometimes to not write things down. And again, there's times maybe you shouldn't. But when someone is asking questions about a process that took place oftentimes years prior, when I'm speaking with clients that they're not trying to commit fraud, they are trying to do the right thing. And when those steps they're taking, the conversations they're happening, the caution they are exercising, the different, hoops they are thinking about, when those aren't captured, it can be hard to remember later. And now you might have a timeline that looks very fast, which sometimes is not a helpful fact. You might have very little that shows the deliberation that went into a decision. And now you have, getting back to the facts don't lie, you might have a decision that at the time, was the right decision and was deeply considered and thought about. But 4 years later, the only reason you're ever looking backwards is because something bad happened. So that decision maybe was the wrong one. So now having any kind of documentation and support around the process you went through is a good and helpful thing.
How do you do that well? And were there cases at the SEC where you came in, maybe guns blazing, something had happened, and then it turned out that no, people were just trying to do the right thing, and what did they do?
A lot of times that's when you get into the witness testimony. So getting that, three-dimensional view, that isn't always possible, depending on someone's memory. Sometimes facts about around that deliberation are privileged, which is challenging. But what's most helpful is where you have, agendas, minutes, topics discussed, even if you don't get into the details of those. And again, there can be reasons not to do that. But showing one bullet point of, discussion on timing, that is actually more than you sometimes see or often see looking back through documentation in what is always a busy and crazy time. And you're just trying to, get the deal done and do the best job you can. And I find it's helpful to talk to clients, especially, GCs, CCOs, heads of business units of, if you had to piece this back together, like if you're making a scrapbook of the deal, what do you have that is capturing these boring, day to day things you are doing that is the support for how well you did your job? And it's okay if things go badly later. If you did your job along the way, sometimes things happen. But how can you show that you did your job and you were keeping, shareholders' interests at the center, that you were thinking about the business in this, multi-layered way? And I think it's surprising to people because oftentimes when I get a new matter and I'm talking to a client now that I'm on the defense side, and I'm like, okay, great. Can you send me any notes on that or send me any emails on that? Send me any meeting invites around that. They are certain they have them and they go back and look and they very often don't.
The scrapbook of the deal is an incredible concept. So what makes a great scrapbook? Like I want to pull on this metaphor. Okay. And I know exactly what you're talking about. Company gets to be of any size and you hire employees. GCI, now we're at 30. And, we're in situations where it's exactly right. I'm doing a million things. I don't think I appreciated before I was a CEO, just the absolute breadth of the job, which is like funny because I was a GC. But anyways, that's where it's at. The thought of scrapbooking, I mean, it's just like parenting. Like you don't have time to scrapbook. So what makes a good scrapbook? How do you do it? And I could totally empathize with like, oh, I had notes on this. You go back to Slack, you don't. So tell us, like, put us in the moment. I'm a GC, and it's like, all right, I'm gonna do some scrapbooking to thank myself later. What am I doing?
What was the subject of a meeting? That usually just says meeting. And again, I understand I'm talking about a best case looking backwards and redoing it. And in the moment, that's probably not going to happen. But when you have, and this has happened, over 1,000 meeting invites that say like meeting, we're now relying on, your memory and other people's memory and insinuations that can be gathered from, emails going on at the same time. Because again, you're only looking back at a story when something has gone wrong. And that I think is such important context because it's not that, people are trying to tell a negative story. It's that let's say something happened, the deal busted, stock absolutely shattered to the floor. And in hindsight, it's clear there were some bad decisions made that seemed good at the time. I mean, meeting timing. announcement details. I mean, almost anything, including people in your discussions, thinking of processes. Like early on, I think that's something that's very hard, especially for a newly public company, which is often who I'm representing. You're going from this process where you're kind of throwing out press releases as a private entity whenever you think you need to. Well, now you need process, and you need process before you think you need it. Who has to read it? Who is going to sign off on it? How does that work? Is there an email showing it went to the GC's office, and then that went back to the executives? Process and procedure are really what protect you. And that's something I'm always trying to convey. It sounds annoying, and it sounds like you have this person, usually the poor GC or CCO who's trying to get everyone to follow the process, but that process protects you. It shows that you were, taking a deliberate approach to the things that you did. And business leaders are allowed to be wrong. You are allowed to mess up. You're allowed to have bad things happen. That doesn't mean there's any kind of, fraud or, shareholder action that's going to have anything successful. You were doing your best, you were being deliberate, and you were, caring for the company in a way that is pursuant to the duties that you owe it. And process is how you show that.
So much wisdom there. So I remember, law school, the business judgment role. Is there anything you could say that's comforting to people? Like, because I hear this and I'm like this, like, super, super boss lady issuing subpoenas, working with the FBI, all these things. And you're telling me process is good. So I hear that. But what's the good news?
The good news is that you're allowed to get things wrong. Like you're allowed to be human. You just need to act, in the at the time trips people up the most, and this gets into the business judgment rule, is not having a good flow of information. The CEO can't and shouldn't know everything. That's just not going to be a functional organization. But there has to be, and again, I'm going to say the word process, a thoughtful process in how information, especially bad information, bad facts, bad sales, an unexpected number of returns of a product because they're not working that wasn't expected, bad facts. There must be a process for them to get up to decision makers to decide, is this information that needs to get up to the C-level suite, and can those executives look at that information and decide if it's something that needs to be disclosed. As a defense attorney, I am so much happier to see a very bad email have gone to the CEO or CFO and them decided, this is not material, we don't need to disclose it, than to find a very bad email that did not make their way up there, because now I'm having to defend and say it's not material from this set aside view, not from inside the organization. And I'm trying to explain why it's okay they didn't know about this. Much better if they knew about it and they, as experts in their organization, thought about this and made the decision that it's not material. That is now protected by the business judgment rule. You had process around that. You had disclosure controls and procedures that got potentially relevant information in there not to disclose it. What we don't want is finding these bad facts that got kind of stuck somewhere in the organization. We can still work with that, but it is easier if it is potentially material if it got to the person who gets to decide that.
Love that. I love that. For me, from the inside, the way I looked at this was, I've said this before, I'll say it again. Amazon had an incredible legal department. And one of the things that I think made it so was the extreme customer obsession. And that showed up for us as product counsel. And I had an incredibly good relationship with the heads of customer support for the products that I worked on. And things bubbled up that way. And, for example, I think Kamala Harris, and this is public, when she was the state AG, came after a bunch of app makers for essentially allowing children to run up charges in app stores. And Amazon was one of the defendants and did just fine. And part of the reason that there was some leniency, or that the case turned out the way it did, was there was internal emails saying, hey, we're getting complaints about this all the time. What are we going to do about it? And, they still paid a fine. And, I still remember the famous thing was, it was a Smurfs game. And there was a kid that had run up $800 worth of Smurf berries. And the question was, do you refund it or not? And so it was kind of an interesting one. What's your story? I have to imagine 10 years of the SEC. Is there some story you can tell us, some case? Maybe you had a real estate client or something like that. But I'd love to take that advice, which is incredible advice. Like, you're getting free $1,800 an hour advice here. on the pod post, but I'd like to take that advice and make it real. What's the what's a good story, or what are you most proud of in your different enforcement actions you did?
Gosh. So you mean from the SEC side or from the private practice side?
Either is okay, whatever you're more comfortable disclosing.
So I had some on the SEC side that I am really proud of. I will say the ones I'm most proud of are the ones that were, I mean, I would say true fraud. It's not the case we're talking about of, hindsight and trying to make sure everything's clear. I mean, there is fraud, and it's always very satisfying when you feel like you have found it and brought that to light, and hopefully maybe got been able to get some money back to the victims of the fraud. In private practice, I mean, my best cases, which is a funny part of my practice, are secret because the SEC's investigations are not non-public. And if you can, get their questions answered and, satisfy them that there was no, fraud here or missteps or failures in controls, the matter's closed and no one ever has to know about it. The irony being that's something obviously I would love my potential future clients to know about. So anytime you're talking about your, more public successes in private practice, you're talking about something where an action was brought. And sometimes, that is the result where you end up. But I did have, a client who it was a priority of the current SEC was looking at these whistleblower protection provisions. It was, certainly a non-intent, no C enter, no fraud, but it was a violation of an SEC rule, or the SEC saw it that way. And so there, your goal is, okay, if this is going to be an action, our goal is to minimize the damage both reputationally, financially. And, one of my goals always is, look, if we're coming to where we think there's going to be an action here, let's stop spending money on the defense part, on the investigation part. If you, the government, have already think you have what you need, then let's start talking about the result. Like, let's jump ahead. We don't need to then spend one more year pulling documents, doing witness testimony. I mean, all of that is very expensive, and it's an additional cost of whatever resolution you end up reaching. So let's just get there. And so in this one, we were able to negotiate in part because the client did such a good job, cooperating, showing all the changes they'd made in their organization. We had an extremely minimal fine based on the size of the company. And even better, there were future cases on this topic, including one, I think a week later, that was, many times, many millions more, than the fine that we were able to secure. So that's one where the client's still happy they have a case, no, but it was a very good result.
Yeah, so just to give you all an idea of scale, she's talking about a $50+ billion company, and the fine was in the very low six figures, which is like less than a 1 month bill on a large patent matter. So yeah, and absolutely and this actually gets me to another topic here. So which is AI, right? So there's a lot of discussion. We see it among our 950 customers of what's going to happen in the billable hour. So I hear a story like Rebecca's where, yes, at the time she's billing $1,800 an hour. And I tell everybody that asks like, hey, what's the profession going to look like? And I'm like, look, people like Rebecca, 10 years at the Securities and Exchange Commission, knows the enforcement priorities, knows the attorneys, has literally seen it all. She is the kind of expertise that AI does not replace that. So that's kind of our baseline. That being the case, Rebecca, what do you think? Where do you think the billable hour is going in that scenario? Because in this case, you delivered for this particular client, $50 billion company, fine in the low six figures, delivered an incredible amount of value. And for their future employees and the policies that they put in place and, all the things we discussed. But how do you square that in a post-AI world? And what are your priorities for your own practice?
I wish I had an idea to replace the billable hour because I do not like it. I don't like it in that entering time is like the bane of my existence. And also in that I don't think it rewards the kind of like efficiency, creativity, getting to the end of a problem that I think should be the motivator as defense counsel. And I think, is all of us want to do our best for our clients, but we're literally paid by the hour. And so it would be nice if there was some kind of way to reward, the idea or plan that works out, that really is efficient and kind of jumps to the end. I don't know what that is. In part because so many other factors are at play. It's like you could maybe think of a success fee, but sometimes that's out of your hands too. You're dealing with a counterparty that you don't control. The thing that worries me about the billable hour is our junior associates. So I think for the partner, you're bringing in, let's say, a tax partner who knows an incredibly detailed part of tax law. He's almost 2,000 an hour. He bills 1 hour and gets you the advice that you need. that is still that is worth it, because that 2000 an hour, whatever it is built in, hundreds of hours and years of experience and all the times you've read the tax code, the interpretation, you've applied it, like all that is in that hour. What worries me is the junior associates, because they're not bringing as much to it. They can't. They're coming out of law school. They know how to think. And then the rest of the time is learning how to be a lawyer and how to be practical and how to work with a client, how to work with another party, how to look at a massive pile of facts and documents and pull out what actually matters. And the only way to do that is practice. And the only way to do that is to watch it. And in our world, you're billing for all of that. And I do think that is hard. It's hard for me as a partner staffing junior associates. And I have found clients are willing to pay when you explain the value proposition. And so sometimes it's also just having kind of frank conversations with clients where I'll have maybe a second year on a phone call with the client, because that is more efficient than me after the phone call, calling the second year, relaying what was said, talking it through. You're now getting my time twice. Well, I'm more expensive. So it's really better if that person is on the call. They're also learning. They're learning from the client. They're getting these facts directly. They're the ones in the documents. They're in the details. They're able to put things together. I cannot, because I have read a fraction of the documents that they have. So that's my current workaround, but I do worry about it.
So when the clients want that efficiency, the cost transparency, are they asking for AI now?
Yes.
And how do you address that? And are you using it? And then how are you helping train that second year?
We certainly use like AI assisted review. So, when we've got, a whole bunch of documents that we are reviewing, and whether we're responding to a subpoena, sometimes there it's still a little tricky, because you have obligations under that subpoena to the government that, you have taken certain steps to review and assess the document. So we have to kind of figure that out case by case. Where I think AI is particularly helpful is an internal investigation, where the obligation is to the client, that you are, you're digging in and trying to find out, what happened, if anything happened, is there any substance to allegations maybe someone has made. And AI is very useful there. And there, I think AI is great as long as a human is at the other end of it. So that's where I talk to clients of, yes, we can use AI to help us figure out what are, helpful search terms, how are documents connected to one another, what is a timeline that can be pulled out of all of these facts. But then you need a person who has done investigations, who's talking to me, talking to others, saying, you saw that, let's dig more there. Because there's a lot of things that don't seem problematic unless you've done a bunch of these investigations, and there's some threads to pull. So I think you can hybrid that, but there's still, I do think, something a little bit lost in not just getting raw data and learning what actually leads somewhere and what doesn't.
Let's go back to the SEC. I'm just fascinated. What's going on in regulatory now? Let's start with AI. So we've seen a couple of SEC enforcements around either AI risk or claims that companies are doing AI and they're not. So what's the takeaway? So a lot of us are GCs. Obviously, I'm, running an AI company, so we've got our own jam. But most companies, whether it be manufacturing or retail or financial services or healthcare, are thinking about AI in their companies. Like that is a thing. I think I read something that like 50% of public company earnings calls had the word AI last year. Give us the regulator perspective as far as you know. And then I know Chair Gensler had talked about AI. What's the current regime thinking, or regime? I don't know if you use that word, but anyway, administration thinking. Yeah. So give us an insight into enforcement and AI.
Two separate issues. So there's AI where companies are claiming they're using it where they aren't. AI right now is a buzzword. Customers, investors like it, especially those who don't understand it, but know it's something that's being talked about. And so therefore a company that's using it is probably a good, cutting edge, going to do great things kind of company. So you're getting a lot of companies, I think AI washing is the phrase right now, kind of taken from the greenwashing when being environmentally conscious was cool. And so now AI is. And so they're saying, for example, there have been a couple SEC enforcement actions where like funds have said, oh, we're using AI to help us figure out, the best stocks to put in here. And it turns out, no, they are not. It is still some people at a computer making those decisions. And that is just disclosure fraud. I mean, same thing with the ESG cases. Those were never a unique enforcement arm. It was just disclosure fraud. You can't say things that you're doing and not do them.
I feel the same way about privacy. Like when privacy got hyper technical, like, yes, of course, GDPR and you need to comply. But the basics of do what you say what you do. This is like as in-house counsel, it's like in my toolkit. And I felt that way about AI washing. And I think I even talked about this in a GCAI perspective is like, we don't say we do things that we don't. And that's just like, it's just part of it. And I do think, again, I feel like an Amazon shill, but Amazon was big on this where like that customer trust of like, if you say it's going to be delivered in 2 days, deliver it in 2 days. If it's not, you tell the customer, like this kind of thing. And so I think that makes sense from AI washing. Has the SEC abandoned kind of ESG at this point? Like what should I be thinking about ESG as a general counsel or a CC?
I mean, with the caveat that I'm obviously not there right now, and most people who even are there are not working right now because the government is shut down. I would say that the SEC's official stance is that ESG is not a priority right now. They disbanded the ESG task force. My defense counsel position on that is kind of what I just said. ESG was never a unique facet or, task of the SEC. It's disclosure fraud, having false disclosures about your environmental impact, about your social commitments, about your governance. That's still just as problematic as it ever was. And I think if, the current SEC found clear misstatements in those areas, or they would certainly consider bringing it and they would certainly investigate it because those aren't ESG cases. They're
Just
disclosure
run of the
cases.
mill disclosure. Okay. So AI washing category 1. What's category 2 of kind of areas that
Category
regulators are?
2, I would say, is risk factors around AI. So companies are using it more and more and telling the truth about it. And so they're starting to put in AI risk, and that's great. It's great to disclose a risk. I think the next step, though, is how are you mitigating that risk? How are you talking about how you are mitigating that risk? And how are you thinking about your internal controls and your disclosure controls in light of AI risk? Because just disclosing a risk doesn't completely get you off the hook. It gets you a lot of the way there. It is very important to disclose potential risk. That said, if then, something happens, you also have to look at the fact that because you're only asking questions when something bad has happened, you as CEO and CFO sign certifications with your own name that get filed with the SEC that say you have designed, implemented, and reviewed your disclosure controls and your internal controls over financial reporting, and you have deemed them satisfactory. And so having the disclosure is great, but how are you then controlling for that risk? How are you thinking about that? How, and sometimes it takes a little while to figure that out, and that's fine. Part of evaluating is evaluating. So, but once you start maybe seeing examples in other companies or, you're seeing risks actually bear fruit, now it's okay, how are we working to prevent that risk? Or do we even have that particular risk? And you're continuing to both refine that risk factor on one end, and that's great, but you really want to be able to show that you are working on controlling for that risk on the inside.
Love that. So again, I think like for me, I did a lot of marketing compliance at Amazon, and it was like the substantiation and, even things like, okay, the battery power, the battery lasts 3 days or what have you. We always did we had tests. We literally had like scientists who tested this, and we had that, and we kept them on record. And it gets back to your documentation point earlier. So I love it. I do feel like with AI, there is, it's obviously so new, and I do think it's changed the practice tremendously. And it's been, the job of a lifetime working on it. But I do feel like on the legal side, there's a lot of like what's old is new again, or what's new is old again, whatever the expression is. But it feels like you validated that. I love it. All right. So you said before, let's switch gears a little bit and talk about kind of the soft factors around being, a very successful law firm lawyer, which you are. So you've said business development is personal. And, you're obviously here on this pod. Hopefully listeners can tell we're friends. You're not just like this hired gun. So what does that look like? How do you develop a partnership like that?
I mean, it's probably corny, but just genuinely day by day. I mean, I really so when I first left private practice and went to the government, I wanted the expertise of the SEC and I wanted that kind of clear path for my future. But there's also a part of me that genuinely believed I would not want to be a partner in big law because I thought like having to sell myself would be terrible. Like that just made me so uncomfortable to even think about. And so I thought this was a way I could kind of not have to go out and find my work, which was true. But coming back to private practice, I mean, one of the most wonderful things I found about it is how personal it is. I mean, you are an advisor and a counselor, kind of in the highest sense. I think, especially in a practice like mine that often is, crisis based. If you're a GC and you get a subpoena from the SEC, that is a scary moment, no matter what the underlying facts are. It's a lot of uncertainty. You're not sure what to do. You don't want to do anything wrong. You're concerned about this whole organization that you're, responsible for, and reacting in that way. And that, okay, like, I am here. I have knowledge that can help you, and talking and building that trust, learning about the organization. What are your biggest concerns? What immediately came to mind when you received this subpoena? Like, let's talk all these things through, because what I have found is a good 90% of the fears are actually something I can allay. Not all of them. And we've got to learn a lot of things. And that's something I have to tell clients too. Like, part of my job is to put on my old hat and investigate you, so that if there's anything to know, we know it before the government does. But a lot of the concerns are ones, we can talk through and explain how the process works, and, make it feel a little more familiar. And in doing that, you build that relationship of trust that, obviously my clients hope to never see me again. But if they needed me, they would know I was there. But also, people in their circle, in their contacts do. And I do a lot of governance and advisory work that kind of that does go forward also.
Love that. I love the like comfort. I mean, I have had, for me, we I think by the time this episode airs, it'll be public that we recently raised a funding round, and I love it. And I'm so excited about the next phase, really excited about the investors that we're gonna have. But even notwithstanding that, I've been a general counsel, I've done funding rounds as large as $1 billion, and it's still like, I don't know how I practiced for as long as I did, because it's still doing a disclosure schedule still makes me kind of nervous. Like, we had an employee that transitioned, and there was a question about that. And I got the email, and it was exactly like you said, where it was like, ooh, like, this is like, it just makes you nervous, even though we objectively had done nothing wrong. In fact, the employee had left of their own accord. So it was like one of these things where it was like, and having, in this case, the outside counsel that I spoke with, and it's high stakes, right? So the SEC comes knocking. You're like, you're worried for your job, you're worried for your company, you're worried for your stakeholders, even if in fact, and like you said, in most of your cases, nothing happened. All right, so put us in the moment. Crisis comes, they get the subpoena from the SEC. Is it usually a phone call? Is the person nervous? Like, what are you doing? And then, like, obviously you've built a successful practice. You've been very intentional about it. How do you make that transition from the like, hey, you got to tell me everything because I'm your friend? How do you do that?
I mean, that also takes time. And frankly, it usually takes a little bit of trial and error, because even if someone truly wants to, like, unburden every potentially negative fact to you, they don't remember half of them. And or they don't remember what is otherwise a completely innocuous email that I am reading, pretending I am still a staff attorney without context, with a potentially, like, negative view because I think something's happened. And then all of a sudden it looks different. So a lot of it just takes place over time. So at the start, it's, I think, really just assuring your client that you know what you are doing. Here is your experience. Here's how these things have worked out in the past. And making sure from the beginning, this is important to me, you give the entire spectrum of outcomes. I am optimistic. I do believe that we're going to achieve, a successful result. I don't know what successful looks like yet. And oftentimes, neither does the client. I mean, you're talking usually to the GC, maybe a member of the board, someone at the C-suite level. They might not know there were some bad facts much further down in the organization. And so part of that is explaining that to them, and explaining that this happens, and that, along the way, we're going to find things that maybe look bad. And then part of our job is getting the context around it, talking about, is this something we bring to the government's attention on our own, especially if it's otherwise covered by the subpoena and they're getting it anyway, and provide the context around it in that moment. So they're not sitting on the document for months thinking they've got this slam dunk. And now you're trying to unconvince someone of something they think. That's much harder than trying to set the stage kind of with the facts in the moment. But I just found it's communication, it's talking through things, it's being very practical, and it's bringing up those practicalities. Like, I understand your concern. This is going to be, expensive. It is. But here's how we're going to work on narrowing that. Here's how we're going to start. And we'll only go out to these types of, subjects if we have to. Here's just bringing them in the fold, because I think people can understand a lot once they're brought kind of inside and understanding what you're thinking about. And they know that, you're on their side and you have the same goals as them. And it's just taking it day by day.
I love that. So you've said publicly that you're unabashedly pro big law. Now that's like, I actually loved my time at Big Law. Still, I hired Morrison and Foerster, my outside counsel, where I'm an alum. Wearing the high heels and the big skyscraper and the really doing this incredible analytical work. Like I do think that there's a lot of things to like about Big Law. Nevertheless, it is a contrarian opinion. It's an easy punching bag. What makes you unabashedly pro Big Law?
It is I'm someone who I would still be in school if someone would pay me to be there. I would love to just study new topics every couple of years, become an expert, and then go study something else. And to me, Big Law is the best practical, profitable ability to do that. I think, in-house counsel can handle an awful lot and do handle an awful lot of day-to-day matters. You are brought in, especially in my practice group where, I am the investigation or SEC defense counsel, something really big has happened, something very hard has happened, something that they need that outside perspective on. And you get to dive in and literally get paid to dig into difficult facts, to, complicated situations, a lot of people, dates, things that happened, disclosures, the law. And weaving all of that together along with the personal element of it, which is, incredibly important and something you're also doing every single day. I think that is the best job. And I mean, I truly love what I do. I also love that and I have not ever been at a small firm. So that also may all apply. I just haven't experienced it. But also at a large firm, done well, I think the mentorship and apprenticeship that can happen with associates is something I also love. I've benefited from that enormously as an associate in my early years, getting to watch other attorneys practice law. There were maybe 8 or 9 partners in my practice group, and all of them practice differently. And I practice differently from all of them. But phone calls, meetings, just being copied on emails and seeing how they're, writing to clients, to one another, to associates, absorbing all of that. And now, getting to be part of that is something I really love.
It's this thing where now as a CEO, I think about it of like, how do you get people doing what they love? And we've talked about it and you've written about it on the blog. And I think you and I have a lot in common of just this the word nerdy kids that love to read.
Oh, yeah.
So like I just loved it. Like I literally I'll read this stuff for fun. And like at one point I was doing very niche IP practice and like what does the word license mean? And and I feel like AI now it's like the Super Bowl for IP lawyers and it's so fun. So yeah, no, that's great. I think that's wonderful. And like I know if you're a younger associate reading this, go work for Rebecca because and that's what you want. It's like people that are genuinely at the top of their game. And that's the thing that's like been so fun for me from a management standpoint is like how do you motivate people? How do you find what it is that they find most interesting? So they bring that joy to work and want to do more of it, like you just described. So yeah, I remember actually, I'll tell a little story. I went to dinner with at Morrison Forster, and at the time, the co-chair of the firm, and it was the bubble times. It was let's say it was like I think it would have been like 807 before the crash, and there was a group out of Stanford Law that made this petition that was like, we're going to have fewer billable hours in Big Law. And at the time, I'm like, I'm savvy enough to know I ain't signing that. Like, what the hell? But anyway, it comes up, and the chair of Morrison Forster, we were talking about it. I didn't bring it up because, whatever. I was savvy enough not to do that. But another associate brings it up. And he made this point that I remember, whatever, 18 years later. And he's like, what I think that doesn't realize is that when you're really good, your clients want more of you. And so, like, they want that counsel that you provided. So it does kind of, to your point, create this tension. And, I think that like getting into work life balance. So, that's actually a nice segue. So, you've been a mom the entire time you've been a lawyer, and your family's always been part of the picture. I'm the same way. Disclosure, I literally found Rebecca's blog when I Googled, can you be pregnant in law school? And she's still today, that is the query that lands people on her blog the most. Is that right, Rebecca?
Oh, out. I mean, for that, and I was pregnant in 2006 and 7, but yes.
Yeah, I mean, they didn't have, TikToks and stuff about being pregnant or whatever. I don't think TikTok existed. But in any event, like this is literally like Blogger. It is so good. But what has that taught you? Like, I mean, I have my own perspective. I could talk all day about it. But like having a family and I don't want to be sexist. Like this is I would ask a dude this too. But the point is like, has it changed anything about your practice or like how have you done it? Because I frequently get people that are like, how do you do it? And I'm like, you just do. Like literally that's my advice is like you just do. But what's your point of view?
I mean, day to day, you just do it. But so yeah, I had my son in law school at University of Chicago between 2L and 3L. So I started, big law practice with a 1 year old. And this was before, remote work was really a thing. Video calls weren't a thing. If you were calling in, sometimes you could kind of tell you weren't calling in from the firm system. But I always just approached it. I don't know, maybe I just didn't know any better. I just decided it was going to be fine. Like I was going to be a great lawyer and I was also going to go home and have dinner. And I definitely was at a firm and in an office. I was in Austin that was just always a little more flexible from the start. And that was definitely part of it. I'm sure there are places where this would not have worked. But I found, at least in Austin, most people left, by 6 anyway, or around then. And then you could just log back in at home. We didn't have as many calls from home as people do now, but I logged back in almost every night and would answer the last few emails that came through. Or, we had Blackberries then, mine was always out. I was still incredibly responsive. I don't think I ever had more than 10 minutes go without responding to an email, but I was home. And, maybe I just wasn't important enough, but I wasn't getting emailed every 5 minutes, like all night. There were lulls, and we would have dinner. I would put him to bed, and he was one. He went to bed at like 7 o'clock or something, or 7:30. I now he's a teenager and goes to bed way after I do, but it could work. And I built, the reputation early on that I did good work and I was responsive, and even then in a very different environment, I really think that's mostly what partners were looking for. Like if I email you, can I trust that you'll read it and get back to me without me having to go back through my sent mail and try to figure out what I've sent out that hasn't come back around? So that always worked. And I never could stay late. I mean, daycare closed. Couldn't go get like drinks with friends after work. And while I'm sure both of those things would have been nice, they weren't things I ever lost because I never had them. So when I had my daughter as a second year associate, it was kind of more of the same. And then I had my second daughter when I was at the SEC. And yeah, you just kind of keep filling it.
Thing is, like, I almost hesitate. Like, I had this in the script because I think you inspired me so much in this area. But the takeaway that I'm hearing is like all the reasons that you're a good lawyer is also the reasons that you're a good mom, and you can just do things. This is literally the thing that is like, and I would say even in my case, it inspired me also to be a CEO. It's like if I can juggle, a bunch of kids and big jobs, then I can do anything. And like that ends up being the message for me. And so yeah, I love it. So check out our blog. It's at laglive, I think.com, LAGLIV, or you can just Google it. Blogspot. Let's go. All right. Throwback to the early aughts. Okay. So let's go. Let's do some quick takes. So what's a book, principle, or habit that has shaped how you lead?
I wish I'd read these. So my only books that I read are like fantasy novels. So I can't, I mean, maybe I'm pulling.
She has a
things from-
great blog. If you are into fantasy and romance, she does reviews. She's got recipes on the blog. Like Rebecca is one of the most real people I think you will interact with. Like the
There's
kind of
something
the contrast of this like incredibly, boss kind of like SEC, like, you might get put in jail kind of day job. In the sort of like, bodice ripping sort of romance novels that she reads at night. It's like I just love it. And people make fun of me too. I was reading sometimes I did a thing with The Economist. And yes, okay, I read The Economist, but I'll pick up Us Weekly. I'll get them both. And the lady at the airport store is like kind of looks at me funny, but you know what? It's fine. It's good. It's good. I love it.
10 Ks of keys all day. I'm going to read about dragons in my office.
Exactly. 10 Ks in the morning, dragons at night. It's good. All right. So what's a piece of advice you'd give a lawyer that's starting out right now? Like, so they're joining your office, or they're joining, client as corporate counsel.
Think long term about your career. And I think this is very hard to do because when you're coming out of law school, you don't, know how to be a lawyer, especially if you didn't grow up around one, as I did not. And so what I was thinking was important to me in a firm or a mentor very early on. I think, I happened to find some good ones, but it wasn't because I knew what I was doing. And think about like how you want to practice, how you want to handle difficult situations, observe and soak up and be a sponge as much as possible. I mean, the one thing, so I've now been a lawyer for almost 20 years. Things that I thought would never apply to me or examples I thought I would never pull from. It's amazing how over time, this happens with parenting too. You think, oh, that won't ever apply to me, or like that story isn't going to matter. And then like 15 years later, you've got a very different, second kid from your first kid, or, whatever. And you're like, I wonder if that would work here. Same thing with law. It's absorbing it all. And while I believe passionately that junior associates should get credit for like all work that they do, that they shouldn't have to, be on client type, calls and matters and not be billing for it. That said, if there's an opportunity to attend something, you're not going to be able to bill it. If it's a partner you admire, if it's someone who's really good at what they do, think long term and watch it anyway. Be part of it anyway. And in looking at a law firm, looking at just the junior associates isn't really what you're going to be. You're an associate for 8 to 10, maybe now 11 years. You're a partner if you stay in big law for 30. So look at the partnership. Look at what they're doing, who they are. Did they start there? Did they all come from somewhere else? How do they think about the firm? What do they like about it? I mean, it's important to ask associates that because your day-to-day life matters. But again, that is such a small chapter in your professional book compared to the time that you are a partner or in-house or doing whatever it is your goal is to do once you've learned how to be a lawyer.
I use the metaphor of like, I get people relatively frequently who are wanting to leave big law. And I say, it's like orange juice. You just squeeze all the juice out of that. And I had a mentor now. She's in-house at a big company, but she was a partner at Morrison Forster for a long time. And she told me very early on, she said, and this is the unsavory way to say it, you said the very positive way, is like use the firm like the firm uses you. So like go to every event. You want to learn about cybersecurity, you go to the cybersecurity event because who knows, 10 years when you're a GC, you're going to have security reporting too. So yeah, that's incredible advice. Any other parting thoughts for us, Rebecca?
Made me think of her advice was all I tell people have certain, boundaries that are really important to you and do not move them because the firm, and I've worked at 2 of them and I love them both, the firm does not care about whatever your boundary is the way that you do. In fact, they generally don't care at all. That's something that's important to you as a personally, I think it's your job to explain or to make it important to them and then stand by it. But just as important, not everything can be critical. Not everything can be a boundary. So when I think about, like my work-life balance, such as it is, things really important to me, like attending, events, being there for nightly dinner, that just day-to-day downtime was so important. Going to my kids' field trips, I learned early on, I frankly don't care. I think I
Yeah,
should care,
I'm with you.
but I
I mean,
don't.
it's also or like volunteering or like cutting up papers or whatever. I'm like, can I just like give money? In the one-on-one, like I love doing art with my kids. I was just like you, where I did not love doing art in a classroom setting. And so like, very similar.
Exactly.
Oh, all right. Well, hey, thank you so much. That was super fun, Rebecca.
Thank you so much for having me.
Awesome. That was my conversation with Rebecca Fike. So follow CZ and Friends wherever you get your podcast. Visit gc.ai to learn how legal teams are using AI and work smarter, lead with impact, and run into amazing advisors like Rebecca, who I hope if you ever need to hire her, she is at Reed Smith. If you have an SEC matter, she is without question the best. So thank you so much for listening, and we'll see you next time.